Well, thank you very much, folks. And we do have another measure, Assemblymember Calderon. Hopefully this one's a little easier. Oh, yes. I'm your principal co-author. Oh, good. All right. Excellent. This is file item 18, AB 856, and I'll go ahead and, no, I can't move the bill. I need somebody else to do it. Assemblyman, please go ahead.
Good afternoon, Madam Chair and members. Today I'm bringing AB 856, a measure which will close a loophole in existing law to clarify that it is trespassing for paparazzi to fly a drone over private property. Last August, I co-authored a joint resolution, a joint oversight hearing of the Assembly Committee on Arts, Entertainment, Sports, Tourism, and Internet Media, Judiciary, and the Select Committee on Privacy convened to explore drones in our future and opportunity and privacy considerations. At that hearing, we learned that the paparazzi have used drones for years to invade the privacy and capture pictures of public persons in the most private of activities, despite existing law. Existing law contains two provisions relevant to drone operations and the paparazzi. First, creates a cause of action for physical invasion of privacy. Second, it is constructive invasion of privacy, which states that a person is liable for invasion of privacy when they use any drone or device in an attempt to take a picture or record a conversation, but do not actually enter onto the property. Last year, the second type of trespass, constructive invasion, was amended by AB 2306, which was Assemblymember Chow, to allow for action against a person using any device in an attempt to capture an image in an effort to address the problem of drones used by the paparazzi identified in our informational hearing. However, the amendments did not change the prohibition against using drones to actually trespass in order to invade another's privacy. AB 856 corrects this oversight by adding the words, including airspace above the land or another, into the definition of physical invasion of privacy. In closing, this bill will prohibit the use of drones to cross over fences, bypass gates, and travel into private sanctuaries in order to spy on the private lives of public persons. In support, it is supported by paparazzi reformers and law enforcement. There is no opposition. I respectfully ask for an aye vote.
All right, we have a motion. Any witnesses in support? Witnesses in opposition? Good bill. We need to, again, start addressing all this great technology we've got. It's moved way ahead of us, and we've got to try to catch up. So we have a motion which is due pass to the Senate floor. Please call the roll.
Jackson?
Aye.
Jackson, aye. Morlock? Anderson? Morlock, aye. Anderson? Hertzberg?
Aye.
Hertzberg, aye. Leno? Monning? Wykowski? Aye. Wykowski, aye.
4-0, that bill is on call. Thank you very much, Assembly Member.
Thank you, Senators. Appreciate your time.
You bet. All right, next we have Assembly Member Rendon, file item 16, AB 723, file item 16. Good afternoon.
Good afternoon.
Almost good evening. We're there, getting there.
Thank you, Madam Chair and Senators. I accept the amendments related to disclosure in comment 3 on page 6 of the analysis, and I want to thank you and your staff for your help in developing them. AB 723 is a bill that uses an existing contract to enforce existing law. In 2009, Senator Padilla authored legislation that required all inefficient plumbing fixtures to be replaced with water-conserving fixtures by 2019. The law held owners of rental properties accountable for replacing these fixtures, but did not designate any state agency to enforce this requirement or oversee it, and there is currently no penalty for noncompliance. AB 723 takes a small step and discloses the requirements to landlords and tenants. This bill requires the property owners to disclose during the lease agreement process that the property contains noncompliant fixtures that he or she is responsible for replacing them. This bill does not change the deadlines for compliance in any way. This bill takes a small proactive rather than reactive approach, especially when saving water has never been more urgent. I want to be clear that Senator Padilla's legislation was well-grounded, but we need to start thinking about enforcement now. If we do nothing, 2017 and 2019 will come around, and the knee-jerk reaction will not be good for anybody. The fines for noncompliance will be steep, and there will be unmanageable pressure on cities to enforce them. I think it's time for the state and private associations to prioritize this, as we cannot rely strictly on one sector. I'm willing to mediate the conversation. I look forward to working with those here in committee today and other stakeholders to come up with a collaborative approach. I respectfully ask for your aye vote.
Thank you very much. Witnesses in support? If you want to step forward, or if you just want to indicate you're in support, we'll take that as well.
Jennifer Speck on behalf of the California Association of Realtors. We're not in support of the measure, but we wanted to kind of show up in the neutral position. We had released a letter on pending amendments related to conversations that we had had with the author and his staff, with the commitment that he is not going to include the proposed amendment that would create rent withholding for noncompliance with SB 407. Sierra is going to remove its opposition and will be neutral as the bill moves forward.
What is it you would like to see happen if it's not withholding rent? How should this issue be dealt with, in your opinion?
The way the California Association of Realtors looks at it, it's up to the county enforcement, so building code or the water purveyor. Having tenants enforce these kinds of provisions, it's not necessarily the right avenue. There's generally a contentious relationship between landlords and tenants. Tenants also don't generally have the expertise to be able to identify a 2.1 flow shower head versus some other kind of shower head or the fixtures.
So your folks would be okay with having the county come in and inspect your rental property to make sure that you're complying?
From what I understand, a lot of local areas already do inspections. We are also required under SB 407 under renovations starting in 2014, and whenever you pull a permit, you are required to come into compliance with SB 407. A lot of our properties are coming into compliance as we move forward towards those date certain requirements.
What about the dwellings that are older than that and that don't meet those requirements? I mean, who should be paying for this? How do we make sure we get this major water problem? We want to get everything complying as quickly as possible. How do we go about doing that? Who pays?
Well, the first part is education. We're taking a proactive approach. We have included a disclosure within the transfer disclosure statement. We sponsored legislation back in 2011 by Senator Blinkley, I apologize. And that was to include disclosure to both buyers and sellers to make sure that everyone is aware that this is an impending requirement coming down the line.
Well, that's buyers and sellers. What about renters?
Well, right now we have a voluntary flyer that we hand out. Our realtors are equipped with to give to all consumers and to include in their advertising materials.
But who's to pay to get the new equipment in? That's the question. Is that the responsibility of the tenant or of the landlord?
Oh, it's the responsibility of the landlord. Tenants are never responsible for replacing or renovating a property. That's up to the property owner.
So how would they then? How would this process then work? So that the new shower heads, the new low flow toilets, all the new or updated equipment is in place? How do we get that to happen?
Well, right now, if a building owner of multifamily property or single family property pulls a permit to do a change or an alteration to the property that I forget what the dollar threshold is for pulling permits, they're required to come into compliance.
Right, but if they're not pulling permits, if this is just, I'm assuming we're looking at some fairly modest rental properties where there are older fixtures and equipment, how do we get them in compliance as quickly as we can to reduce our water consumption now?
Well, I know the trade associations, ours, I believe the California Apartment Association, I don't want to speak for them, but we're all doing education of our members to make sure that they're aware. With regards to education in the state of California, I think Department of Water Resources and other agencies are also responsible for bearing the burden along with the PUC and the utilities in order to provide the necessary education for property owners.
Okay. Thank you. All right, then if we could have the opposition come forward. And if you would state for us as succinctly as you can.
We'll do, Madam Chair and members, Shanta Pekin on behalf of the California Apartment Association. We are actually opposed unless amended. We are requesting that the author and the committee consider changing the disclosure date to 2019 so it in fact corresponds to the requirement in law. It's unclear to us what is accomplished by requiring a disclosure 2 years in advance of a requirement to actually do anything. Should we have the state require that every rental property owner or business for that matter disclose every single state law they're required to abide by, even the ones that are years into the future? All we think this will accomplish is require small mom and pops to significantly change their leases or provide additional documentation without actually accomplishing any of the goals of the bill. It's not going to require any retrofit. They don't have to do anything until 2019. And the idea that an owner may not know about the 2009 law that was passed, well, they're certainly not going to know about this current disclosure requirement that's going to be in effect if this bill were to pass. So they won't be compliant. They won't do the disclosure either. So for those reasons, we just simply ask that the bill actually be amended to move that date to 2019.
Thank you. Next witness.
Madam Chair and members, Matthew Harg with the California Business Properties Association, and I just want to be clear that I'm here representing the commercial side of this. It's a little bit different than residential because the state treats usually commercial contracts, leasing contracts, as business-to-business contracts. They're a little bit different than on the residential side. I worked on SB 407 and my association ultimately supported that bill. Some of the questions that you're asking now were asked at the time and were contemplated at the time. And what many of the groups that worked on that bill suggested at the time was that this idea go through the same process that normal building codes go through. At the time, we said if the state doesn't step up and tell property owners that this is something that they have to do by 2019, nobody's going to know except for those property owners who are already sitting at the head of the class and are parts of our associations. As far as we know, that there's no state agency. There's no utilities that have been directed to let property owners know that this is a 2019 goal. On the commercial side, through the natural order of things, we believe that most of our members are already in compliance with this because you have to be in compliance with ADA. If you haven't done ADA since 1994, then you've got an issue. You have to respond to tenant improvement requests out there. On the commercial side, there's really no buildings out there that's going to have a 25-year-old bathroom that is responding to tenant requests. We think where a lot of these issues are going to be are on the commercial side, some of the structures you're talking about, kind of owner-occupied, smaller buildings. How do you get to them? Well, you get to them through the local utility. Just first of all, a notice to them saying you have to comply with this. And then we would also, along with that, suggest that the state put together some money for a program to help those property owners that might not have the capital up front to do this. Now, it's not a huge expense. You're basically swapping out some toilets, some shower heads, and some faucets. But we do think that there's some properties out there that aren't going to know about this, and the state has a duty to make sure they know about it and assist them. Thank you.
Thank you.
Madam Chair, members, Steve Carlson for the Apartment Association of Greater Los Angeles, Santa Barbara Rental Property Association. We echo some of the comments made by my colleagues. A couple things. In Los Angeles, since the late 80s, anytime a property is sold, they've been required to retrofit, even predating the Padilla bill, and it has happened ever since. So there's plenty of that has already taken place. I think that there's an assumption out there that it's like assumes facts, not in evidence. I mean, the assumption is, well, nobody's doing this. Well, I don't think that's true. And folks are doing it. Plus, as water costs go up, as penalties for overwater use go up, and as many owners in particularly rent-controlled areas cannot pass on the cost of water to their tenants, it would be pretty silly of an owner not to do that because at least they're going to use water less water at a lower rate.
Okay, thank you. Appreciate that. Okay. Just name and affiliation, please.
Jennifer Tannehill with Aaron Reed and Associates on behalf of the San Diego County Apartment Association. Just want to echo the concerns previously stated and note that we would like the notice moved to 2019 as well.
All righty. Thank you. Any other witnesses in opposition? Bringing it to the members. 2019, that seems a long way away with the drought that we're having. If there aren't any questions, if you'd, Assemblyman, if you'd like to respond as you close.
Thank you, Madam Chair. You brought up the idea of enforcement. Folks from the Apartment Association brought up the idea of the problems relating to information dissemination. There are a number of questions that still need to be answered relative to SB 407. This bill seeks only to address the disclosure component. That's all we're seeking to identify. By identifying early that some fixtures are non-compliant, we are only again addressing those properties that are in non-compliance. If most are in compliance, that's great. They won't be impacted. This only seeks to impact those. This only seeks to provide notification of those that are in non-compliance. As such, it's limited in scope, but it's important. Within the context of the drought that we're suffering through, within the context of residential water use, this is a very important step, and I ask for your aye vote.
Very good. All right. Is there a motion? Moved by Senator Wachowski. The motion is do pass as amended to Senate appropriations. I assume you'll be continuing to work on the measure as well. I would like to say I don't want to move it to 2019. We have a serious drought now. We're talking about putting AstroTurf down in place of lawns. The least we can do is have faucets and other articles installed, and I can tell you they're not that expensive, surprisingly. That's a good thing, but the cost of water is getting more and more expensive and more difficult to find water. So I think that going to 2019 is just unrealistic and unnecessary. So with that, but continuing to work with the opposition on things that might make some sense in this circumstance, I would certainly support. So do pass as amended to Senate appropriations. Please call the members.
Jackson?
Aye.
Jackson, aye. Morlock? No. Morlock, no. Anderson? Hertzberg? Aye. Hertzberg, aye. Leno? Monning? Wachowski? Aye. Wachowski, aye.
All right, that bill has 3 to 1. It will be on call. Thank you,
Thank you, Senators.
All right, file item 20, Assemblymember Levine, AB 900. We've got 5 more bills after that, so we may get out of here tonight.
Thank you, Madam Chair and Senators. I will attempt to be quick for you, and I really respect the time that you've put into all of the bills before you today. AB 900 aligns with federal law to allow courts to establish guardianships for youth up to 21 years of age who could be eligible for special immigrant juvenile status, known as SIJUS. Those eligible for SIJUS are among the most vulnerable children and youth imaginable. Without access to this federal immigration path, these individuals would face abuse, neglect, and possibly death. I'll keep my comments there and allow Erickson Albrecht with Bet Zedek Legal Services and Rachel Prandini with the Immigrant Legal Resource Center to give more testimony.
Thank you. Very briefly, I think we're probably pretty well versed in the issue and understand what you're promoting here. So go ahead very briefly, if you would, sir.
My name is Erickson Albrecht. I'm the attorney at Bet Zedek Legal Services who handles probate matters and SIJUS requests. Sounds like the committee is well versed in this issue. From our perspective at Bet Zedek, we've recognized a population who have suffered, have a past marked by abuse, abandonment, and neglect, and whose futures are additionally limited both by the significant disparity between their customs and culture, as well as any language barriers that they have. AB 900 would allow these youth, age 18 to 20, to have access to the probate court to seek out the protections of a guardian as minors younger than 18 already have. Thank you.
Thank you. Next witness, very briefly.
My name is Rachel Prandini, an attorney with the Immigrant Legal Resource Center, and we support this bill. It will fix a misalignment between California law and federal law that's currently preventing youth between the age of 18 and 20 from accessing federal immigration relief that they're otherwise eligible for. It will also allow this class of youth to have the assistance of a legal guardian, which is very important for youth who've experienced high levels of trauma and are adjusting to life in the United States. So we do urge your vote in support of AB 900.
Thank you.
Thank you.
Other witnesses, briefly.
Michelle Carey with the Los Angeles Center for Law and Justice, also in strong support of the bill. We also serve this particular community. We see on a daily basis the high level of need and the need for protection and continued support, and this bill will do important work for that vulnerable community. Thank you so much.
Appreciate it. Witnesses in support, name and affiliation, please. All right, if you would, see if we can't fix that. There we go.
Steven Sepulveda, California Immigrant Policy Center, in strong support of this bill.
Thank you.
Angie Young, Bay Area SIGES Task Force, in support.
Thank you.
Noah Paramo, California Rural Legal Assistance Foundation, in strong support.
Thank you very much. Any witnesses in opposition? Seeing none, we have a motion. Thank you very much for bringing this bill. This is very important to these youngsters who definitely need this assistance. So with that, any questions, anything at all? Nope. All right, let's have a motion. We have a motion by Senator Hertzberg to pass the Senate appropriations. Please call the members.
Jackson?
Aye.
Jackson, aye. Morlock? Anderson? Hertzberg?
Aye.
Hertzberg, aye. Leno? Monning, aye. Wachowski. Wachowski, aye. Leno, aye.
All right, that bill has 5-0. We'll put it on call. Thank you very much.
Thank you so much, Senators.
Thank you.
All right, next is file item 21, AB 998 by Assemblymember Wagner. Good, still afternoon.
Thank you. Good afternoon, Madam Chair and members of the committee. Briefly, I'm here with AB 998. This bill is in response to a court decision last year out of LA County. Currently in the law, we protect our newspapers, and if you are going to try to sue them for libel and get special damages, you're required to request a retraction first, and there appears to be a hole in the law. What the court identified last year is that online publications are not subject to the retraction demand, and according to the court, quote, had the legislature intended the statute to apply to defamatory material published on an online website, it could have amended the statute to say so.
Move the
close
bill.
Quote. Thank you. This does that, closes that loophole. The statute was last updated in 1946. Assuming the internet is here to stay, this is a loophole we ought close, and I urge an aye vote.
None too soon.
You can always tell a Hastings man, but you can't tell him much.
All right, well, we'll see. We have one witness in support, if you'd like to keep it brief.
Absolutely. Madam Chair, members of the committee, Jimmy with the California Newspaper Publishers Association. This bill would recognize modern technology and modern news cycles. We urge an aye vote.
Very good. Any opposition? Seeing none, any questions? Motion? Motion, that's right, by Senator Hertzberg. The motion is due pass to the Senate floor. Please call the members.
Jackson?
Aye.
Jackson, aye. Morlock? Anderson? Aye. Anderson, aye. Hertzberg? Aye. Hertzberg, aye. Leno? Monning? Leno, aye. Monning, aye. Wachowski? Wachowski, aye.
6-0, we'll put that on call. Thank you very much, Assembly Member. Next is file item 25, AB 1178 by Assembly Member Shajian. Good afternoon, sir.
Good afternoon.
Nice to see you.
Thank you, Madam Chair and members. I would like to start by accepting the amendments reflected in the committee's analysis. I'm here to present AB 1178, which will strengthen California's current laws by prohibiting manufacturers from taking negative actions against a dealer when a vehicle is exported or resold after the dealer has collected sales tax and registered the vehicle in California. 2 years ago, the legislature created a rebuttable presumption that the dealer did not have knowledge of the intent to export so long as the vehicle is registered in California and the sales tax is collected. Unfortunately, California's motor vehicle protection laws did not anticipate that certain auto manufacturers will ignore these recently passed laws and export and resale policies. These manufacturers have instead enacted punitive practices against dealers, including holding franchisees strictly liable for exported vehicles, even if the dealer collected sales tax and registered the vehicle in California. The punitive practices include reducing vehicle allocations, withholding or charging back incentive monies, and threat of terminating the franchise agreement. AB 1178 would prohibit manufacturers from taking negative actions against a dealer when a vehicle is exported or resold if the dealer collected sales tax and registered the vehicle in California. I have with me Cliff Costa with the California New Car Dealers, here to testify in support and answer any questions you might have. Thank you.
Thank you very much. Witnesses in support?
Madam Chair and Senators, Cliff Costa on behalf of the California New Car Dealers Association. I'd first like to thank your committee staff for writing an excellent analysis and for working with us on some amendments. We're here because 2 years ago we agreed in a Senator Padilla bill to create a rebuttable presumption that if the dealer collected sales tax and registered the vehicle here in the state of California, that they did not know that the vehicle ultimately was going to be exported. The language in the statute says that a dealer or a manufacturer cannot threaten to take action or take adverse action against a dealer if he knew or should have known that the vehicle was going to be exported. What's happened since then is not just one manufacturer, Jaguar Land Rover, but now 2 manufacturers we just found out this morning that Volvo has also instituted an export policy which pretty much says this: we don't care what the California statute is. If you do not take reasonable due diligence steps and the vehicle ends up after you've sold it in another country, then we're coming back after you. Jag Land Rover's policy says that 3%, if 3% end up in another country within a quarter, well, then they're coming after you in vehicle allocations as well as monies, incentive monies they owe us. Volvo's policy is even worse. If the first vehicle gets exported to another country, well, then all of a sudden you now are being reduced your vehicle allocation for that line make for 5 vehicles. If 2 ends up overseas, 10 vehicles. If 3 ends up overseas, they now threaten to terminate your franchise agreement. We don't think that this is a reasonable step. What we have seen is now not just complete ignoring what the current statute is, but the requirement from the dealer to have to ask the customers when you come in to purchase the car, well, why are you paying cash? Can you tell me what bank account that's coming from? Can you tell me why you're not putting a down payment? Can you tell me why you're not trading the vehicle in? Can you tell me why you've traveled 100 miles to purchase this car? Can you tell me why you don't want a service contract or an extended warranty? These are the things that the manufacturers are asking us to do. What we are trying to do in 1178, Mr. Sajian's bill, is create a bright line. What are the rules the dealers need to do? We have been working with the manufacturers. We are continuing to work with the manufacturers, but it's simple. If the dealer collected sales tax and registered the vehicle here in the state of California, unless the person's on a known exporter list, which is provided from the manufacturers, or unless the dealer actually knew that the customer was intending to export, well, then the dealer can't have an adverse action taken against them.
Thank you.
Thank you.
All right. Any other witnesses in support? Witnesses in opposition? And is it Jaguar or Jaguar?
I call it Jaguar.
You pay more for it if it's a Jaguar.
Right.
Got it. Then it's a Jaguar. I'll buy a Jaguar. You can buy a Jaguar. Okay, very good. Sorry about that. All right. Good afternoon.
Good afternoon. Thank you, Madam Chair. Members, Ivan Altamura with Capital Advocacy here on behalf of global automakers. We are opposed unless amended to this bill. It's important to point out that dealers and manufacturers working together is the only way that that enforcing an export policy and preventing these types of transactions from ending up overseas will work. And I think it's mutually agreed that it negatively impacts both the manufacturers as well as the dealers that when vehicles end up being sold and then going overseas. It also impacts the consumers of the state of California by not having product available in the California market that is intended to be sold in California. And for those reasons, as the sponsor and the author have both stated, there was a recognition that we needed to work together 2 years ago to create what was at that time SB 155 by Senator Padilla, which established the current protections in law that if a manufacturer had an onerous export policy and they in fact did enforce it against a dealer, that the dealer would have recourse under the law to challenge that action taken by the manufacturer. And essentially, if determined that action was unlawful according to the current franchise law, that policy would be thrown out, or that action taken by the manufacturer would be thrown out. We believe that the current law is fair and it's balanced because it provides protections to the dealers that they presume that a sale was presumed to not be intended for export, but at the same time, it does give some recourse to a manufacturer to challenge particular facts in a sale that the dealer reasonably either knew or should have known that a vehicle was intended to be exported. It's important to note that...
Please wrap it up. Your 2 minutes.
I appreciate that. It's important to note that that the manufacturers right now that have these policies that we believe are in violation of the California law, that those policies under the current statute would be thrown out. That being said, as the author stated and as the sponsor stated, we are continuing to work together. We are trying to find a resolution.
Thank you. Thank you very much. Next witness, please.
Gene Urban on behalf of the Alliance of Automobile Manufacturers. The two members denounced by Mr. Costa are members of the Alliance, Jaguar, Land Rover, Volvo. These are high-end cars. At some level, it's just a question of scarcity. These are two companies facing bankruptcy a few years ago. Now, because of the renaissance in the automobile industry, there's not enough product to sell. We're not unsympathetic, but we need a more balanced approach. I am hoping that we can talk to the dealers about the administrative equivalent of a declaratory relief action. If the policies, if the letters they have received violate the law, I'd like to know that. I'd like to know it sooner than later. We are prepared to accelerate that decision by the new Motor Vehicle Board. And if it's the administrative equivalent of a declaratory relief action, assuming the dispute's sufficiently ripe and all that, I'm all for it. But having to prove actual knowledge is a step too far. It's only going to exacerbate this problem. So we're opposed unless we can come up with some slightly better compromise.
All right, I almost feel like we should be in B&P over this, business and professions.
Why are we here? What's the jurisdiction?
I think our jurisdiction is a question of fairness in the negotiations and the balance between the two, because I see this as really a question of who's got more power. It's a little bit like the franchise bill, to the extent that it's, you know, do we go with the manufacturers? Do they have greater sort of control and power, negotiating power than the car dealers? Probably they do. I guess you can pull your franchise, your dealership rather, if you don't like what's happening. On the other hand, as I understand it, there is the product availability. There's also the price. The prices differ between you know, if there is a good faith arrangement, as I understand that there's supposed to be between the two, that you sell a car, that it's intended to be sold for a certain price in the state of California and so forth. So, you know, the only problem I have, and I know this might take us back to where we were, is when you require that they knew, that somebody knew. The law, we always say knew or should have known.
Well, yeah, exactly
because you know, to walk away from something where, because you don't want to hear what the person's saying, for example, if you just stood still, you would know what it is. Or and by walking away, you really should have known what was being said. And you can say, hey, look, I didn't hear it. You know, I wasn't there. So it's a sort of a requirement that it's a reasonableness requirement, I think, that you knew or should have known. I think that's in virtually every legal construct whatsoever, that you have knowledge or should have known. And I think the fact that that isn't in the bill is what disturbs me. Otherwise, I think it's, you know, I think what you've done is to try to make an accommodation, and that's really what we're, I think, here to try to do. So I would ask that you put in the bill not only knew, but should have known, knew or should have known. That's the standard that we generally have. Why can't we? That was in Padilla.
That was in Padilla.
All right. So could you respond to that and then go ahead?
Yes, Madam Chair. It was in Mr. Padilla's bill, and it's being ignored because we have dealers who have received those threatening letters while the law exists. And if I may, as of 4 hours ago, we met and we're willing to continue our discussions, but timing is enough in essence, so we have to come to your meeting here, and hopefully it will move forward. Then it will give us almost a month to continue our discussions. There are different ways to look at it. If a dealer was to sell a car at a retail price, person who's buying the price, registering in California, paying sales tax, then shipping it someplace else, the price has gone up. And if they're still able to take to a different country and make money, why wouldn't the manufacturer go open a dealership in that country and sell their cars? Or why wouldn't they give incentives to the dealers in that country to compete? I mean, it's as simple as that.
Yeah, except that isn't the agreement. I mean, are you suggesting that?
I'm saying that just the common sense approach in the business world. But I hear what you have said, and we have also discussed that we should come back with a simple way of asking few questions without making the buyer feel like they're a criminal. We're questioning where they're coming, where they're going. But few questions that by law we have to ask these questions. Is this for import, export, the purpose? And they check a box and sign, then we'll put the dealership in a safer comfort zone that they did their due diligence and sold the car basis that it is to be sold here.
Madam Chair, if you
excuse me, one more thing.
Yes, sorry. Thank you.
If
Please
I may,
continue.
Madam Chair. If I sell a car with all, I've done my share, and this person chooses to take it down the road and burn it, that's there. They pay the price. I've done my share. I've sold the cars. The thing that's missing that I'm having a difficulty understanding, both manufacturers and dealers are in the business of selling cars. The more cars they sell, the better for the manufacturer. I don't see where the problem is, but to threaten their dealers in the way they are with the law that exists, it's just not fair.
I should send you out to talk to the franchisors and franchisees. It's a similar kind of sense of a lack of parity. Senator Hertzberg.
Maybe the way to slice is a little thinner. I mean, the truth of the matter is you don't have to produce, as indicated in the amendment, actual knowledge of a murder. You only have to have beyond a reasonable doubt and the strictest scrutiny. What's an actual knowledge standard? But that being said, the truth of the matter is, I don't know anecdotally, that car manufacturers do engage in behavior that has a chilling effect on dealers, and it's not right. And the dealers are scared to death that they're going to lose or have adversely affected, or, you know, the old story of you order a bunch of green cars and you get blue cars. You know, we've all seen that, how that game gets played. So maybe there's a way to do it with just a real strict scrutiny standard. In other words, to give some flexibility here, because the notion of actual knowledge is an awful hard thing to prove. I mean, literally, I don't know where in the law you have actual knowledge where you've got to prove that in a jurisprudential standard, right? You know anything? Yeah, I don't know either. But what you can do is the reasonable standard has clearly proven the ability to manipulate, right? And clearly has proven the ability of folks that are going to push the line, because you got a lot of middle-level people that have a lot of challenges in big companies, and they're trying to do what they got to do, and sometimes that's why companies get in trouble, because they got mid-level people trying to meet their goals and getting pressured from higher management. But if you set a high standard, a strict scrutiny type of standard, kind of to deal with what the chair is talking about, maybe that will have a chilling effect on that kind of behavior, but ensure that if there is somebody who's engaged in clearly just moving stuff out of the country where it's a bright line, but that you can certainly obfuscate actual knowledge, but you avoid this kind of behavior that we know goes on all the time.
Madam Chair,
Very briefly, and then we're going to conclude the discussion. We've still got some more.
We're perfectly content living with a presumption. If the sales tax and the vehicle license registration fees are paid, that's a presumption that we have to overcome. We have the burden of proof. If it needs to be a clear and convincing standard of proof of actual knowledge, we would be willing to entertain that. We don't want to be punitive. It is a partnership. The author is correct. Right. We want to sell these vehicles, but if there's a scarcity of vehicles and you try to distribute them on a planetary basis in a fair way, it can't be abused. We need to be able to respond in those isolated incidents. It's not widespread. It is higher end vehicles, but the markup is 200 and 300 and 400%. So we need some ability to respond. If it's a higher burden of proof, clear and convincing, I don't want to go to reasonable doubt if I don't have. That's something we would entertain.
Is that something, yes, is that something you'd be willing to talk about over the...
That's definitely something we'd be willing to talk about. We added actual knowledge in the attempt to address the concern that the manufacturer is raising. We don't want to protect dealers who are colluding with known exporters. That's not the attempt of what we're trying to do here. What we're trying to do is not to harass our customers, who is their customers as well, when we're selling a vehicle. That's what we're trying to look for. We also want predictability and certainty when we sell a car, that the car's not going to come back, 6 months, a year later being told, well, the car was exported, we're coming after you.
Got it. Senator Leno.
Thank you, Madam Chair, and I think you have framed the issue very appropriately. And if there seems to be agreement here that a few more weeks is going to help, I'll certainly support that. But I did just want to get one bit of clarity from Mr. Altamira or Mr. Urban. Since this was debated just a couple years ago in the Padilla bill, and agreements were reached, this is my concern about fairness, but again, I don't want to interfere with any kind of deal that you may be able to reach in the next few weeks. In a situation like this, wasn't that which was established in the Padilla bill that if there is a situation, such as what Jaguar is now suggesting, that the adjudicator is the new motor vehicle board? Isn't that where you take it?
That's correct.
Absolutely.
So why isn't that a good place to go?
It's a very good place.
We debate this now.
We think it is a good spot.
And we would support that. I guess one of
That's the law.
That's
Right.
the law.
Right.
And the only difficulty
not
here is the dispute actually ripe yet? Has the adverse action been taken? I'm not unsympathetic. They get these threatening letters. Is that a threat, or do you have to wait to the actual chargeback? Which is why we talked about accelerating it on a declaratory relief action. So
I get the sense we're very close here.
Right,
And
so as I say, I don't want to interfere with it, but
right.
I
So
thought they had a law.
let's go ahead and, with the commitment that you will continue to try to work on this as it goes to Senate, it will go to Senate approach. You'll have time to resolve it. I think you're close. And with that, is there a motion? Motion by Senator Hertzberg do pass as amended to Senate appropriations. With that spirit of resolution, I will support as well. So please call the roll.
Jackson?
Aye.
Jackson, aye. Morlock? Morlock, aye. Anderson? Anderson, aye. Hertzberg?
Aye.
Hertzberg, aye. Leno? Leno, aye. Monning? Monning, aye. Wachowski? Wachowski, aye.
7-0, the bill is out. Thank you,
Madam Chair.
Assembly Member. Thank you all, and I look forward to resolution.